My company has 2 trademark registration in process in the US. Both received a non-final office action with both were responded and are waiting for the attorney from the USPTO to decide.
Yep.
We do have a third mark we want to register. The logo is similar to both marks on the process. If we request this third mark to trademark registration, would that hurt the other 2 that are going on right now?
Good question. So this gets at trademark strategy, right? So a lot of times we have clients who are in multiple different classes at the USPTO. Maybe one of those classes we think we're going to have a problem with. So, if we think one of the applications might have a likelihood of confusion with a prior file application or registration, maybe we don't want to file that one until the other applications have been reviewed by the USPTO examiner. Because what I don't want to do is stir the pot, have an issue with one application over here, and have that issue impute to the other applications because they're all related. USPTO will do that. This kind of gets at talking to your attorney about the strategy. And in this particular case, I would say if there's any hesitation to file based on the likelihood of confusion or descriptive issues or whatever, don't file it right away. File the other ones first. Wait until they've been approved by the USPTO. You get that notice of allowance, then file it.
Got it. So that's similar on the patent side, where you have that parent application and you have something close or similar. We say timeout. Let's wait for that examiner to either restrict or to come up with a rejection. Then you can file what's called a child patent.
Yep.
A little different process, but it sounds like you want to basically get that thumbs up first and then sort of green light to file subsequent related.
Exactly. And that's a strategy too that we use for clients who have maybe a somewhat descriptive trademark. Maybe it's not nearly descriptive, but it's borderline and we're thinking ready to push back. Maybe we file that design trademark first, it registers, and then we cite that trademark registration in our wordmark application afterwards. I think I will say, like in my 14 years doing this, that's kind of something that, as you get more and more experience, you get more reps under your belt, that strategy becomes more apparent.
Yes. Love it.